You're welcome. Great. Good morning. Today is Tuesday, May 7th, it's 9 a.m. It's a meeting Senate Natural Resources and Energy. We are here to act on the bill H 877, enacting miscellaneous agricultural subjects, which came over from the House, went to Senate Ag, and was referred to our committee end of last week. Took some testimony on Friday, and I just wanted to follow up with the council, and then as per agreement with the Pro-Tem's office, which we would act and get it out today so that there's no issue around timing in the floor. Okay. So thank you for coming, Mr. O'Grady. You can talk to us about I think two things. One is the context. We worked at length last year on S-146. It went upstairs, it's been involved since. There's a proposal for some brief language on indirect discharge permits in front of us in 877. And I think the question we had was to try to better understand what the construct we put together last year. That is S-146 was the rule as we understood it at that time, versus what this amendment, the language in 877 can do, minus the rest of 146. And the other question related to that is I've heard different characterizations about what A&R has done with the rule in between. So I know it's a long question, but you've been involved in the whole history of this. Maybe you can help us come up to date.
Sure. This is Mike O'Grady, Legislative Council. I can give you context. I'm not as up to date on the rulemaking as others in the room may be, but I will try to characterize as best as I can. So let's talk about the context first. There's this section, subsection NDSA 1259D, that says no person shall cause a discharge of waste into Class A waters except for on-site disposal of sewage from systems with a capacity of 1,000 gallons per day or less that are either exempt from or comply with environmental protection rules or existing systems which shall require a permit according to the provisions of 1263 capacity. So that is very technical and it's not very clear what that means. So Class A water is a high quality water, and those waters are subject to restrictions and additional protections on their use to maintain those high quality waters, which is one of the purposes of the Clean Water Act and of the Vermont Water Quality Standard. The concern is that 1,000 gallons per day limit on a septic system isn't, it was added to statute in 1985. It was added before the state went to universal jurisdiction on wastewater systems. And it was basically a non-scientific limitation on development in those waters to have some sort of precaution that development in those waters would not impair the Class A water. However, there's concern from persons specifically who are in Class A waters, who are in waters that are proposed for classification as Class A, that this limitation would hinder their development, would prevent replacement of systems in places like schools or stores, and prevent affordable housing, because all of those systems would most likely require more than 1,000 gallons per day. And so that is your kind of your dichotomy, is the 1,000 gallons per day is there to limit development in a Class A water, because that's potentially a policy priority of the state, is to not have development put a pressure on Class A waters, to maintain those waters as they are with their uses now. But the response is that that limit is not scientifically based. Before the universal jurisdiction rules and puts an arbitrary limit on development in areas that need development or will need replacement of systems. So that's the general argument, what you were doing last year in 146 was to how to implement the anti-degradation policy through statute and through ultimately rule to address these concerns. So anti-degradation policy is a requirement of the Federal Clean Water Act that says when a water is a certain quality and supports the uses of that water, then the state has to maintain that quality to support those uses and cannot allow the water to be graded so that the water becomes less in quality or the uses are impaired or no longer are met. So that's anti-degradation. The state, for a very, very, very long time, did not have an anti-degradation policy. It ultimately was included in Vermont water quality standards, but when you have a policy, you also need to have something called the implementation rule. And the state still does not have an implementation rule. And that's partly what you, as a committee, were looking at in S-146 last year, is amending the provisions in 1259D about the 1,000 gallon limit and how it would be implemented under the anti-degradation policy implementation rule. And specifically whether or not there would be called a tier 2 analysis for an individual permit in those waters to ensure that there was no degradation of the water, including from cumulative development in the water, which anti-degradation is supposed to address as well. So you passed, the Senate passed 146, but it didn't pass the House.
And can you remind us what the tier 2 now, I didn't reread 146, sorry, okay? So I'm remembering what we were required of adding the tier 2 analysis.
Hold on a second. So it says systems with the design flow of more than 1,000 gallons per day that are located in class B1 watershed shall be reviewed by the secretary to determine if there would be a measurable reduction in the chemical, physical, or biological quality of the receiving water as a result of the system, and when required under ANR's anti-degradation implementation rule, the secretary shall conduct a tier 2 analysis that includes site-specific analysis and a cumulative impact analysis as required by the Vermont water quality standards to ensure the protection of class A and class B waters. So that's what it was. It's basically an individual assessment of both an assessment of its impact on the chemical, physical, or biological quality of the receiving water, and whether or not with the site-specific analysis and cumulative impact analysis. That's what it would be.
Are you citing 146?
I'm saying reasons.
So
Thank you, Mr. Chair, and thank you, you may not be.
I'm not fully
Okay,
done
then,
because what has happened since you didn't pass 146 is that there are waters that have been identified as capable or meeting Class A standards, that the agency isn't going forward with reclassification because they are concerned about this 1,000 gallon per day limit and its effect on development. Whereas the environmental groups are saying that because they've identified these waters as Class A eligible underneath the Clean Water Act continued planning process, they need to classify them in order to protect them. It's a standoff, it really is, and the advocates are advocating for a stronger anti-degradation implementation rule that includes something like that independent analysis in those Class A waters when it's over 1,000 gallons per day. And then you're hearing a lot of disinformation too, that a town petitioned ANR to reclassify the water and ANR canceled the hearing. And isn't that illegal? And I'm like, no, the classification process is by rule. Statute says that a person can petition the agency and the secretary has to respond according to the APA petition processes where they may hold a hearing, they may amend the rule. It's discretionary. They don't have to hold the hearing. They don't have to amend the rule. But so you're now in this kind of,
Sure, and the rule amendment process is to add a body of water to the list in the.
it's to reclassify, change it from most likely a B2 to an A or A1 or A2, depending on what its use will be. And that's what it's done through rulemaking. Maybe it shouldn't be done through rulemaking, but rulemaking is a check on it that runs it through you, the General Assembly.
So for places now that are concerned about potential to replace the system, if they haven't reclassified to A,
Then they can,
then they're under the existing rules and the 1,000-gallon limitation doesn't
it
apply.
doesn't apply to them, and they can put in a wastewater system up to 6,500 gallons. Because that is the upper limit of what a wastewater system is. Over that, you need to get into direct discharge order.
Sure, so, and perhaps this is the question I was trying to ask earlier, but you may have answered it, so. So one of the points of debate was there were systems, community systems, which are more than one household that need to be upgraded or repaired. Maybe even that is two different answers, but they can do that even if they are reclassified in these waters.
That's a good question. I don't really know the answer to that. I think honestly, the agency is gonna say no. Because without the reclassification, if they're still in B2, yes, they can do a community system, most likely a mound system. If you've ever been to a lake in the last 15 years, you've probably seen a mound system. You might have been standing on a mound system and you didn't know you were on a mound system. But
Probable.
if those one or more houses fail in a class A water, there's the argument that they have, honestly, I think ANR is going to implement the 1,000 gallon per day limit. I think because the wastewater rules include what's called the best fix. When you fail, the agency and you, the General Assembly, didn't want to make people leave a house.
Yeah.
They wanted to keep the house habitable, but with the concept that not all parcels will be able to meet the current universal rules. So they say you do what's the best fix for that failed system. I don't know if there'd be 3 houses in a row that the agency says best fix. I think they're just gonna say, no, each has to have its own best fix of 1,000 gallons per day or less.
Oh, okay.
Which is gonna be more expensive and not as potentially environmentally protective as a community analysis.
Okay, cause that I feel like was a point that we heard, but it seems like we have an amendment before us on H77. You know, since we're very short on time, I don't know if we want to vote on that, because I do feel based on this conversation, at the very least. I don't feel comfortable with the language that we have at 877. That's, I mean, this is a very complex topic, we had a whole bill on it. It seems like a not great alternative to just have, what, like a paragraph in the farm bill?
So except that, can you tell us just what precise thing that 877 proposes to do as opposed to addressing that whole picture we've been from the top?
So 877 would propose elimination of the 1,000 gallon per day limit for newly reclassified waters that are classified as A after the effective date of 877. Those that were classified before would remain with that 1,000 gallon per day limitation. What it doesn't do is it doesn't have the language that was in 146 regarding how the agency would do permitting in a class A water over 1,000 gallons per day. It doesn't have that directive to do the individual analysis and the tier 2 analysis. And it doesn't have any other thing that was in S 146.
Yeah, so I don't know if you, how this exact amendment came to us, but if I understand.
And that's correct, I asked Mr. Ray to draft on behalf, based on my sense, one, that I think we had very little time. And two, we had to act today. Three, based on our conversation last week, I had a sense that we found proposed language of miscellaneous ag an incomplete solution to a complicated situation.
And that's how I feel, it looks, if I'm understanding the amendment correctly, that we just take out that section.
I think we'll go to remove that section.
That's what I'm doing.
Yeah, I didn't start that.
Is so we have all 5 more minutes. It's possible the finance won't start right away. Anyone in the room want to, thank you, Mr. Zaghi, contribute to the conversation?
Mr. Chair, I would move that we offer that we amend House Bill number, we offer to amend, I don't know the right language for this.
We go on the bill.
Okay, what did we,
Yeah, so we're we reporting the bill favorably with the proposal of amendment.
that's what I would like to do.
Do you don't wanna amend it first? I trust you did.
Well, we would, okay, our usual formal way is first vote to amend and then to report favorably to those so amended. So let's stick with our regular knitting here. So the first motion would be,
Vote to amend 877 with the amendment draft number 1.1.
any further committee discussion?
We,
I have not seen Senator Down.
I guess I would just say this does feel like an unresolved issue and we need to pick it up at some point.
Yeah.
Yeah.
I wrote, thank you for that. I wrote to folks who were here last week, over the weekend and said, you know, we realize that this long pending issue is in no one's best interest to leave it unresolved. And so I asked people to be willing to have a discussion over the summer and fall and come back in January and we would have, you know, maybe we're tuning up S-146, I'm not sure. We need to hear from the agency, but I look to get a commitment for like moving something promptly. The other from our side, which I think is, you know, very doable. Of course, none of us knows if we'll be here, but anyway, assuming we are. Well, and then the challenge will be in part to interest our House colleagues in addressing it as well. Sort of, I get it, it's a backhand development, proxy for managing development around in or around Class A waters. But it seems like, I think I'm remembering our whole conversation last year, why not do it directly and explicitly rather than implicitly? It's just a favorite no. So, yes, please.
and this is on the amendment to it, so McDonald, McCormick,
Yes.
Watson,
Yes.
White, yes, Chair Bray.
Yes.
Okay, so that one is 401, and then I would move that we find the 877 favorable with offer of amendment.
Any further discussion?
McDonald, McCormick,
Yes.
Watson,
Yes.
White, yes, Chair Bray.
Yes.
Okay.
So, we have between courts. The next one,
Dan.
get the bill and take it upstairs.
Cool.
We have that next off right here.
But look, we got about just like 2 minutes to spare.
Fair. So, you know, for people who are currently watching, who are wish that we had an answer, I'd say problem with the answer proposed in 877 was that it had, I think, many unintended consequences or potential for it, so we need. We need a more solid answer that supports people who live in the environment. And now it's kind of a false choice. Right, thank you, Mr. Grady, thank you, everybody.
So I think you definitely use.
So then,
Yeah.
so one
I think so. You might have to build, you were gonna leave it right on the desk.
Oh, that one that I just